Hello and welcome to Edukemy's YouTube channel and editorial discussion for 22nd April 2022. My name is Harsh Singh and in this video we shall discuss an editorial from The Hindu which is titled Unfounded Apprehensions about this Act. The editorial talks about various provisions of the Criminal Procedure Act which has only lately been given assent by the President of India, and this act is the one that replaces the age-old 1920 act called as the Identification of Prisoners Act. Now, this article has been written by a police officer and representing the points of the administration and the efficiency of this act. And therefore, in this video, we'll talk about both the sides of the aspect. If you like this initiative, share some love through likes, comments, and shares. Let's begin. To begin with, let's just discuss the apprehensions and the issues about the Criminal Procedures Act. The first one that is being commonly shared amongst the media and persons is that there is a wide horizon of persons who are being covered in this act. It is not just meant for the people who have been accused, it is also meant for those people in suspicion, also meant for the people who have been apprehended because of preventive detention. So wider horizon is one aspect of issue. Second, the measurements that were taken previously for a person who is a convict or accused, they were limited, but now the measurements that have increased. There is a provision for physical and biological samples to be collected. So this is an apprehension, again, wider horizon and wider ambit of measurements to be taken. There are privacy concerns about the data because data will be stored with NCRB for 75 years from the day of the crime. And along with that, there are issues about self-incriminating procedures, ambiguous provisions, and some scientific techniques which have been spoken or unspoken in the act. Let's understand the other side. See, before anything, whenever a crime occurs, the crime has to be investigated, and forensics do play a very important role. We see here in this image a person carefully examining the samples and the crime site. So modern techniques are mandated for the administration of justice, efficient and expeditious justice which has high conviction rate. If this is required, then we will have to have some ambit for modern techniques as well, right? So the provisions that are being utilized here, they are expanding the ambit, but under legal recourse itself, under what is legally accepted. Let's understand the details of the same. Now, the first thing is Identification of Prisoners Act contained provisions for taking fingerprints and footprints of the accused or the person who has been convicted. And now the new provisions include palm prints, photographs, iris, retina scans, all these, along with that biological samples of the analysis, right? Handwriting and signatures. Now, interestingly, all these provisions which have been now included in the new act, Criminal Procedures Act, which people are saying is a new provision and more data has been taken, they were already mentioned in the Criminal Procedure Code. Such examination was to be done, and this is a part of Criminal Procedure Code, and it has only been integrated in a act now. So this only means that the provisions have been merged and explicitly mentioned in the law, rather than having some fragments in a law and some fragments in the criminal procedure code. So that is why when we speak of taking of blood samples, semen, swabs, sputum, sweat, or using fingernail clippings for understanding if the crime was committed, or identifying the criminal, then these provisions were already mentioned in Criminal Procedure Code, and amendments have been made repeatedly, 1970, 2006 in CRPC, to have these things included in examination of justice. So, and these were also law commission recommendations. So nothing extraordinary has been done. The law only has had merger. This is the first point of defense that the article presents. The second is on self-incrimination. Article 23, that is a part of the fundamental rights, says very simply that no person shall be holding to account their own offense. That means no person shall be accused for an offense and be compelled to be witness against themselves. If I have committed the offense, how can I be telling, yes, I have committed the offense? There has to be some proof externally provided by the state, by the agencies. That's how it should be done. Now, this is a part of principles of natural justice. There are two principles of it. The first one is that no person shall be judged in their own cause, right? So either they are judging their cause or they are being held guilty just because they have some evidence or data. This is one. And the second one is everybody shall have the right to be heard. right? These are the two important principles of natural justice. Please do remember. And to not violate this fundamental right has been issued on the same count. Now, can a person's data be taken? For example, their fingerprint, their footprint, their iris scan, or their biological sample, can it be taken to have a proof against themselves? So this is where the Supreme Court has said that these cannot amount to be a witness, right? So hair sample or voice sample will not amount to compelling an accused to become a witness against themselves. This is a Supreme Court judgment itself. So it is very clear that these data that we are going to take from the person who is suspected or accused, this is not going to incriminate them, right? So whenever we take biological samples or other samples also, this does not convey any information that the accused has. Very important point. This does not convey any information that the accused has in their mind. This is just getting objective data from them. And yes, it might have some help in providing justice, right? Might give some kind of evidence which makes it obligatory to give a good judgment, right? Now there are objections again. Narco analysis, polygraphy, brain fingerprinting test, all this, they could be a part of the new scientific technology instruments that are used to incriminate a person, right? However, they have not been mentioned in this act. The act only mentions that it might use scientific techniques, right? So therefore, let's understand what these techniques are, and then we will understand this, right? So narco analysis means a person is subjected to some kind of drug, psychoactive drug, for example, sodium pentanol, and and after they become semi-conscious, then they wouldn't be lying. Any question asked, any conversation made, and they will be divulging the truthful information. So this is called as narco analysis. Narco related to psychoactive drugs. Polygraphy test. So what is this about? Here, a person is attached with some scientific instruments to their body which calculates the parameters, the biological parameters of the person. For example, blood pressure, pulse, the respiration rate, all of it is calculated with the help of the device which is affixed our torso and hands. And another person is asking them questions. If the person is responding to the questions and there's no change in such vitals, for example respiration, blood pressure, that it possibly means that the person is answering it rightly, right? They know and they are answering truthfully and they're not manipulating the information. That's how usually happens. If we divulge some false information, sometimes our heart rate increases, our respiration increases, we start looking left and right? Similarly, brain fingerprinting, this test is about the same vital parameters to be checked, but at the brain level, right? So measuring while while being asked questions, the brain's response is checked while some words are shared, while some pictures of the accused, while some pictures of some of the crime scenes or the people who are the victims are shared. And that's how the government tries to, or the state tries to understand if the person has committed the crime or not. Now all these tests are not a part of the scientific proof, right? Because they have not been accepted by this act also does not lay down any names of these techniques. So this is clearly such that if these procedures are not used, then we are under the permissible limits for fundamental rights. There is no violation of the constitution of the country because we are not using these kind of tests, right? Rest apart, some objections are about non-cognizable offenses or simple cognizable offenses. See, if the offense has been committed of a very small nature, one person has slapped the other person or gone behind bars because of cheating, forgery, these kind of cases. So biological samples, semen samples, hair sample, all this is not required. If people are held under preventive detention, chakka jam, etc., they are not obligated to give biological samples. Only simple samples like the fingerprints might be required, right? So these are provisions of the act itself, right? Moving ahead to understand more issues and provisions about this, juveniles. Now, a separate mention for juveniles is not there, which is an area of concern. However, the Juvenile Justice Act very clearly mentions how a juvenile has to be treated. For example, if a juvenile is delinquent, if they have committed something which could be a part of crime if they were 18 years above, right? So if juvenile conducts this, right? A social background report is prepared and a daily diary report is prepared, and this is presented at the Juvenile Justice Board, all right, the court for small the persons who are less than 18 years of age. So social background report of the child, what if the child has committed a theft just because they were very poor? So reformation has to be given to that child. Their daily diary report is the police reporting, which is not the first information report. After this daily, every evening, the police, they report all the cases in first information report booklet from the daily diary. So daily diary has to be only submitted at the court, at the board, all right. But for heinous crimes only FIR has to be submitted. This is a part of Juvenile Justice Act. If this was placed, if these provisions were also clarified once again in the Criminal Procedure Act, it would have been good. So you can mention this as a valid criticism also, right? And no measurement of this child can be taken for future references of different crimes, right? Because we are looking at reformation of the child, not to make them penal, right? So some good criticism here. Crime data. See, 75 years is the duration given for storage of crime data. Too much time, right? Average longevity also is around 70 years, 74 years. Assuming the person is committing the crime at the age of 25, why are you saving the information up to 75 more years, amounting to total 100 years? How many people survive 100 years, right? Also, NCRB data, National Crime Record Bureau data, only states that number of people who are arrested for crimes over the age of 60 years is less than 1.5%, right? So one could reduce this particular age up to which data has to be stored, all right. Now the act is not mandating compulsory recording of all measurements for all type of offenses. If minor offenses have been conducted, then every data has not to be given, so people need not fear about the privacy, right? And data sharing will happen by the state authority with other state authorities as well, as and when required, to understand the intricacies of crime or the people who are missing, dead bodies, etc. Okay. See, what is required, we must understand. We need data protection, right? What is required is a parliamentary scrutiny over the act if it is not doing well, all right. And what is required is its implementation. A law is as good as its implementation. Simple. So, lacunae will exist in every law, but then if the implementers are good, the shortcomings will not be exploited, and it will be implemented in letter and spirit, right? So let's look at the primary objectives of this act. The objective was this, that we should facilitate identification and investigation of criminal matters, right? So that there may be efficacious and efficient administration of justice, so that conviction rate is high. And to use that, all the countries are using better techniques, better technology. For example, iris scan, for example, retina scan, having better imagery of the persons, right? Having more ambit of persons covered in this law to reduce probability of errors. So looking at the objective and the social interest in mind, possibly the law that has been created has been rightly created. This is what this editorial concludes. See, this editorial gives a very vital perspective into the other side of the story. Now, just concluding and revising all these aspects, because in this discussion we covered all the aspects. So what are the apprehensions? The apprehensions of the people, rightly covered all the apprehensions. You can also include juvenile justice, data saving for 75 years, etc., privacy concerns of the people, and wider horizon of persons covered, and the measurements taken, all this, right? The self incrimination nature, which the police officer right now says is not a part of it. The scientific test, the narco analysis and brain mapping, all these are not being carried out, right? Now, if they get carried out, then this is against the spirit of the law and protection of human rights, fundamental rights, right? Modern techniques, advantages, these are the advantages. So, understanding that the law has only been merged from the previous act and Criminal Procedure Act, understanding that no person is going to get incriminated against themselves, understanding that scientific techniques do not involve the narco polygraph and brain finger mapping, understanding the fact that the smaller offenses are not obligated to give all the personal data, right? Understanding the information about crime data which needs sharing amongst people. This law possibly uh, deserves its place in the constitution. So understanding both the sides of the story, one is the positive aspects, negative aspects, you need to now put down your notes, right? Both the aspects have been discussed here, and you have now understood the intricacies of this particular law. Now, a small question to you people. Mention 5 opportunities and 5 issues presented in the new Criminal Procedure Act. All that is for you to present and type down in the comment section. Now, in case you have any questions, doubts, just type down in the comment section and we will get back to you. And if you like this initiative, share some love through likes, shares, and subscribes. Thank you for watching.